Hampton ZBA, you are live.
Okay, welcome to the Zoning Board of Appeals meeting for Friday, September 13th. And we'd like to first welcome Joseph DiArco, our new member of the Zoning Board. Thank you. We have the minutes of August 9th, 2024. May I have a motion?
So moved.
Second, please.
Second.
Okay. And we don't have to poll the board on that, right? Do we?
No.
Okay. Determinations for Sophie Hudson, 15 Drew Lane. We have two determinations today, and I'll read them, and the files are available at Village Hall. In the application of Sophie Hudson, 15 Drew Lane, Suffolk County Tax Map Number 301-13-13-4, for 757 square foot variance is granted. Decision is addressed to request for variance relief as a result of which the request for interpretation is moot and or not ripe. May I have a motion?
So moved.
Second?
Second.
Gabby, please poll the board.
Mr. McGurk?
Yes.
Mr. McMullen?
Yes.
Mr. Barris?
Yes.
Ms. Fitzsimons? Yes.
In the second determination of the day, in the application of Stanley DeJong Osborne and Virginia Osborne, 27 Hunting Lane, Suffolk County Tax Map Number 301-3-8-4, for an area variance to make alterations to an existing residence that exceeds allowable gross floor area and to construct a detached garage is granted. To construct a detached, I don't know, we're denying the garage part of it.
Yeah.
Right? So it's saying?
Do you have that updated?
Maybe not.
Yeah. Maybe I have the wrong one.
Yeah.
Okay.
Oh, this is this.
You should.
Sorry.
He has the same one as I do.
So we're gonna.
Okay.
We have that's wrong.
Here's the updated.
Thank you.
It's right here.
I have it from.
Or we can just read it. I have the determination with me.
So according based on the foregoing analysis upon motion of the. Well, I don't know who. Okay. All right, so the application is granted as to the proposed modification of the primary residence and denied as to the variance relief for the sought for the garage.
That's the determination.
Okay. May I have a motion?
So moved.
Second, please.
Second.
May you poll the board?
Mr. McGurk?
Yes.
Mr. McMullen?
Yes.
Mr. Barris?
Yes.
Ms. Fitzsimons?
Yes.
Okay, we have continuing adjournments. We have Beach House Realty LLC, October 11th, 2024, and we have Guildhall of East Hampton until October 11th, 2024. We have the continuing hearings for the day. We have Hunting Hospitality LLC, 94 Main Street. Martha? Good morning.
Good morning, members of the board, Mr. Chairman. My name is Martha Reichert. I am the attorney for the applicant. I'm with Toomey Latham Shea, Kelly Dubin, and Corderaro, 33 West 2nd Street, Riverhead, New York. Well, the last time we saw each other was the May meeting. And since then, we received a request from the village from the ZBA specifically to submit a memorandum of law regarding an issue that was raised at the last hearing by a member of the public, whether or not Village Code Section 278-7C2D3 would bar the zoning board from considering an application for the introduction of an outdoor use at a pre-existing non-conforming commercial property in a residential district. This had been sort of a threshold issue that had been raised very early on, discussed, addressed in our initial application submission, and sort of laid to rest for a period of time until this last meeting when it was raised. So that is the genesis of our memorandum of law, which was submitted on August 1st. I'd like to just take a moment to briefly summarize our memorandum, but also, one of the things that we rely on heavily in our memorandum, in addition to looking at how this particular section of the code has been raised, is ZBA precedent and also a stipulation of settlement in the Hedges Inn litigation that was brought by the Hedges Inn against the village, the zoning board, and the building inspector. So I'm just going to hand out a copy of that.
Thank you. Thank you. Thank you.
Thank you. In a nutshell, so this particular section of the code was enacted in 2014, and it's only come before this board specifically, in terms of my research, once, and that was specifically to look at the issue of the introduction or expansion of outdoor dining at a pre-existing non-conforming restaurant. The rest of the time, when variances have been sought by commercial properties in a residential district, I cited in my memorandum a couple different examples where this board held that those variances were being granted for things that were accessory to the principal use. And I think that really shows through in how this board has approached that particular section of the code. But, perhaps, and again, the reason I distributed the stipulation of settlement here is that with the Hedges Inn litigation, one of the things that the parties sought to do in settling it was also confirm the application of this particular section of the code and how it would be interpreted with respect to a swimming pool at the Hedges Inn. And so what I'd like to read to you is, it is stipulated and agreed that the Hedges Inn may construct a swimming pool subject to receipt of a building permit, provided dimensional requirements of the zoning code can be met, or in the alternative, a variance is granted for same. No use variance shall be required for construction of a pool, as the pool is deemed an appurtenant accessory use of the inn. It is further stipulated that any proposed pool will not be prohibited from obtaining a variance by the provisions of Village Code 278-7 C2D3 concerning the introduction of outdoor uses on pre-existing commercial properties located in residential districts. I would say that this is clear legislative intent and guidance from the Village Board of Trustees that confirms that a swimming pool, even at a historic inn such as the Hedges Inn, in the village is an appurtenant accessory, and that any proposed pool, and in this case a spa and its associated patio, would not be prohibited from applying for and obtaining variances pursuant to Village Code 278-7 C2D3. Our conclusion in our memorandum of law is that there is no basis to treat this application by the Hunting Inn any differently than a potential proposed application by the Hedges Inn pursuant to this stipulation, which again was meant to provide clarity and confirmation. It's axiomatic and has been held by the Court of Appeals that it's arbitrary and capricious when a zoning board neither adheres to its prior precedent or provides a reasoning for reaching a different result on essentially the same facts. And so based on the foregoing, we would like to submit that there is nothing in the Village Code that would prevent this board from considering the area variances for the proposed swimming pool, spa, and its associated patio as an appurtenant accessory to the pre-existing non-conforming inn use. Unless the board has any other questions, I would like to thank them for their time. This has been 2.5 years of hearings and plan revisions in which we have substantially reduced not only the number of variances needed, but their magnitude to the point where all we need are lot coverage variances for the contested pool and swimming pool and patio. And again, I respectfully thank you for your time and request that the record be closed today.
Thank you, Martha. Tim, would you like to address?
Sure. Yes, to confirm, the memo of law that was submitted was at our behest in order to flesh out and address these issues. And we greatly appreciate receiving that, and all the points are very well presented. In conclusion, however, upon close consideration of this provision of the town code, the application of its plain language simply does not confer authority for this board to grant those portions of this application that would involve the introduction of an outdoor use to a pre-existing non-conforming use, commercial in a residential zone. That's what aspects of this application do seek, and that takes this board's normal discretionary ability to relax code provisions away from it, and is simply a bar to its authority to grant that. I understand your point about the stipulation in the Hedges Inn litigation. Ultimately, that's not an expression of this board. That is a resolution of a litigation where parties have different cost-benefit analysis. It doesn't establish a precedent in this board's decision-making powers. So for those reasons, it's simply an application of the plain language of 7C23 to the scope of this application, and there's just those parts of it that are beyond this board's authority to grant.
Thank you. So we just got the EAF from Billy yesterday.
Okay.
So we're going to review it. We're going to close the meeting. We will review the EAF. We'll probably pass the EAF next meeting, October 11th. We will close the hearing and have a determination for you. Right.
Quick question is, you said referred to the town code, it's a village code.
Village code.
Thanks, Joe. Okay. Thank you.
Thank you very much.
Thank you. So we have the next continued hearing for White House Partners LP, 95 Egypt Lane. You want me to read this now?
I think so, yeah.
Okay. Go ahead, Martha.
Did you make a motion to close the hearing?
No, we'll do that next meeting. Thank you. Denise, I'm going to just read this. Application of White House Partners LP, 95 Egypt Lane, insofar as the application seeks in part modification of a prior determination of this board, so much of today's hearing that is addressed to that part, to the relief sought by this application, may be deemed and rehearing pursuant to the New York Village Law Section 7-712, subsection 12, provided that a motion is held, such hearing is made and unanimously approved. Do I have a motion? Second?
Second.
Gabby, can you poll the board, please?
Mr. McGurk?
Yes.
Mr. McMullen?
Yes.
Mr. Rose?
Yes.
Mr. Barris?
Yes.
Ms. Fitzsimons?
Yes.
Mr. Darko?
Do I have to announce that I wasn't at the previous meeting?
Yeah, I don't,
Yeah.
Okay. Should I just leave
Do
it?
you want me to vote on it or no?
It isn't.
he wasn't sitting on it.
So, yeah, he wouldn't vote on it.
Okay.
Yeah, he is
All
not.
right.
So we do have unanimous because he did not sit on the application. Thank you.
Thank you, Mr. Chairman. My name is Denise Shern. I'm an attorney at the Adam Miller Group in Bridgehampton, New York, here today on behalf of the applicants, Mark and Carolyn Goldfarb. Mark is in the audience with me today, and also we're here today with our planner, Shannon McCaffrey from Dewey's Planning. Just first, I would like to hand out a few materials that I think will help during my presentation. First is just a summary of my comments.
Thank you.
Second is a photo montage, the one that you see there, but in a smaller version, so you guys can. Thank you. One as fast as I can.
Thank you.
We can always share if you want. No, that's okay, we can share. If you guys take this one, I'll take this. No, I don't care. Thank you. Procedure.
It's also on this board too. That's good for LTV.
There's no conflict.
So at the last meeting, I was not present. I hadn't been retained yet. This matter was before you in August, and the application is for a wetlands permit and setback variances for a railing to enclose an overhang and for a modest 83 square foot deck on the rear of the house to accommodate. Right now, they have their kitchen equipment out there, so their barbecue grill. So that's what it would be used for. So that's what we're here for today, is those two requests. When I reviewed that hearing, I noticed that there was a conversation that took place after the zoning board had closed the hearing. So there was a member from the audience who came up and approached, I'm not sure, it might have been the vice chair or the chair, and...
Chair was not there.
Okay.
Oh, don't.
I won't,
Yeah.
I'll let you, I'll let
Leave
the,
that alone.
okay,
So-
I'll let the record
And
speak
people
for
were
it.
just sitting at the table when the audience member came up.
I know,
We
there's,
didn't engage the audience member.
I
So let's
understand
get
that.
that clear.
No
Thank you.
disrespect to the board whatsoever, but if I don't bring this up here and put it into the record, I can't use it in the future if I need to in a court of law. So it's my obligation as a zealous advocate for my client to make sure that I do get it on the record. I understand that the village did nothing wrong at all. There were two prior decisions on this application, on this property. The first was in July of 2011. That was essentially to replace the existing house and also to construct the porch, the deck, and the swimming pool. There was vociferous objection to that from the neighbor at 99 Egypt during that application, and also a subsequent application in September of 2012, where the board was asked to determine whether the refurbishment of the garage actually constituted maintenance or reconstruction, because that had to do with whether we were over GFA or not. The board determined that we were not over on GFA and that the rehabilitation was in fact a rehabilitation and not a tear down and a rebuild of that structure. During that hearing, there was also a question about whether the overhang was going to be used as a deck or just a roof. It was made clear by the applicant's attorney that there was no intent for them to use it as a deck. They have a deck on the other side of the residence that gives them more than sufficient room for outdoor space on the second floor. There's actually tables and chairs out there right now. That's what they use as their second story outdoor space. This overhang actually exists at the top of the stairway. There's a sort of a stairwell at the top that's an open space. It's not a room. And our client has put his desk in there. So the desk sits on a wall that faces 99 Egypt. And if you look at, is it okay if I point at something at the board, on the board? Outside window from the desk at the top there. So as you can see, we do have.
Would you do me a favor and just speak next to the microphone so that way we have everything on record? I'd appreciate that. Thank you very much.
No problem. So the top picture here is an image of the window that he looks out of when he sits at his desk. You'll see that he can see a little bit of the swimming pool next door, but not much. We have substantial evergreen vegetation between these two properties. Not only do we have evergreen trees, but we also have very large canopy trees, a stockade fence, and also two accessory structures, one that's owned by our client and one that's owned by the property owner next door. So there's very little view from that room into the backyard of 99. If you look at these images here, you'll see that we were able to obtain on Corcoran's website an image from the neighbor's property into our property, and you'll see the same kind of vegetation. So, sorry, it's hard to hold this. So you'll get a clear image from these two pictures that when standing in the backyard of 99 and looking over at my client's property at 95, what you're looking at is trees, a stockade fence, and two accessory structures that are back to back. I know there was a picture submitted at the last meeting, and it looks like it was taken sort of between the trees. You know, you can see the limbs sort of encroaching into the picture. It's not a clear view from 99 to 95. It's really well screened. There was a discussion at the last meeting about res judicata, and it sounds like maybe you've already made a decision that res judicata applies here. I don't believe it does, and I'll explain why. In the last decision in 2012, the issue that the board was facing was whether utilizing mahogany instead of another asphalt shingles, I suppose, converted that space from a deck from a roof into a deck. And in considering whether or not it was, the board took into consideration several factors. So the board said, you know, we've heard from the applicant that they're not going to use it as a deck. They're not proposing to put a door there. They're putting a window, and they're not proposing any railings. So these were the factors that they took into consideration in determining that using mahogany was not going to convert the space from a roof to a deck. Those were not things that that our applicant had an opportunity to fairly and adequately litigate at that point. And so when that happens and the court goes sort of off the direct path, we call that dicta. And that was, I think, what my client might have mentioned at the last meeting. So we've got a lot of Latin phrases here that exist in the law. Dicta happens to be one of them. And dicta refers to statements that are made by the board in a decision that are not essential to the decision, but offered as guidance or commentary. For today's application, again, we're seeking a freshwater wetland special permit and setback variances for a 36 square foot deck addition, 78 feet from the wetlands, and a safety railing around a 97 square foot second story roof overhang on the southerly side of the dwelling, 84 feet from the edge of the wetlands. It should be noted that while the public notice did state that we were trying to modify the former approval, that's really not the purpose of the application. The purpose of the application is to seek a new approval and to bring out issues and concerns that were not raised during that prior proceeding. To avoid any confusion, we've provided the board with several pictures, as I said. I just want to point out in terms of the configuration of the residence, in the last determination from 2012, there seemed to be some confusion about where the master bedroom was. The master bedroom is actually on the north side, which is where the deck is. And this, as I said, is that landing on the top of the stairs on the south, did I do that backwards? North, south, I did that right. On the southerly side. This is where the deck is. I'm sorry, this is where the desk is inside that landing. And that's the view out over the overhang into the backyard. So what we're seeking from you today is a variance from the wetlands code to install those railings, both for safety purposes and aesthetic purposes, symmetry. I know those issues were brought out at the last meeting, so I won't inundate the board with more comments on that, but that is the rationale behind needing or wanting the railing on that side as well. We don't believe that there's any rational basis to assume that because the overhang would be covered in something other than wood, that automatically it turns into a roof. I think what you would want would be something like architectural shingles, which might not be the best view or vantage point for the client in looking into his backyard, and it doesn't change the use of that area. We're not proposing to use it as a deck. We won't use it as a deck. There's a window that accesses that space, and clearly, if someone wanted to, they could jump out, I guess, or climb out and then jump off the overhang. That wouldn't be a very good idea, but we'd like to prevent it from happening. There's another final Latin phrase that I'll leave you with in zoning. It's for anyone who speaks Latin, I apologize for my pronunciation, but it's secutero ut alienum non ledis, and it translates to use your own property as to not harm others. And I would submit that requesting a railing around this very small overhang, which the neighbor cannot see from his side of the property, is respectfully using the property in a way that will not harm the neighbor. I am available for any questions.
Gabby, who's sitting on this application, so we're just sort of clear?
So we have Mr. McGurk, Mr. McMullen, Mr. Rose, Mr. Barris, Ms. Fitzsimons, and Mr. Carmelli.
Please, questions?
My only comment would be like before, I said I didn't have a problem with the patio area and the barbecue.
Can you move the microphone closer to you, my friend? Sure, thank you.
When it comes to the deck and stuff, I understand asking for the railing to make some symmetry to the house and everything. So I don't have a problem with that. But I think if we keep calling it a safety railing and stuff, that just seems like somebody's gonna be going out there. So in an effort to avoid that, I would say that I don't have a problem as long as we don't put decking up there.
Andy?
I don't really have any comments. I kind of feel similar to Jimmy, where if it's truly not going to be having people out there, then that's less of an issue for me. So
There we go.
No, I agree.
Mr. Rose?
No comment.
I know, we're just having some comments. We'll come to you. We know you're back there, Jeff. So, just while she's here. You're okay. Okay, so, thank you.
Okay, thank you.
Mr. Bragman?
Reluctant as I am to interrupt. I didn't get the paper, so I didn't get a chance to look at this. I have that one. Jeff Bragman for the neighbor to the south, Robert Caruso. I'm going to avoid speaking Latin to you. We've been asking for submissions this whole week, didn't get anything, and this is the first I've seen it, and since it involves views, I'd at least like to keep the record open so that my client can look it over carefully and explain some of the photos that I've seen him take, because and I've been on the site as well, and it is not a blocked view. You can see that protruding part of the house, and I'd like to have an opportunity to submit that and challenge this document, which I'm only seeing for the first time today. I think it's important to think about the context of this application, because separated out from the history of the case, it sounds like a tempest in a teacup, and it is not. This additional railing is intrusive. It's in an intrusive location, partly because of the way the properties are arranged. The Caruso property is like at points 1.2 feet away or 17 inches away from the property line. It's so close that they had to do a boundary line agreement. They're very cheek by jowl. But it's worth noting, I'm pleased at least to hear that you took a vote, I guess, to get a unanimous vote under Village Law Section 712. It also requires that the application be renoticed, which I don't believe it was. So I think that's an omission that is of something that is required under Village Law Section 712.
We'll leave that to council.
In the first application, the house was a tear down, and the only remaining structure on site was this little outbuilding that had a bedroom and basically was habitable. And in getting approval for that, the applicant asked for 6 variances. And so in terms of the number of variances, it's a fairly substantial number of variances. I don't think you see a lot of cases coming in with a request for 6 variances. And in addition, the size of the variances was quite substantial. Landscaping 28 feet from a wetland versus 125 feet, the house 73 feet, the pool 77 feet, the deck 71 feet, which is roughly half of the setback that's required. The sanitary system was 60 feet shy of the requirement, and the drainage structures were only 67 feet from the wetland, where 200 feet was required. So this house got substantial relief to be built in the first place. In the second application, what happened is the first application, and I might add, in the first application, Mr. Caruso came in and objected to a deck that they wanted to put up in this location. And in light of that objection, the applicant withdrew the application for the deck. Then what happened is, it turned out that instead of merely attaching the outbuilding to the house, they substantially gutted the structure. And when code enforcement came by, they cited him for it and said, this could be, they didn't cite, he said this could be a violation of zoning because it's not merely an alteration. It looks like it's, a new enough structure that it would require a special permit. And I might add that in the first application where they granted all the variances, they went through your special permit factors as well. And those factors include any impacts to neighboring properties. So what happened is, they returned to the zoning board in the second application. And part of the reason that it was significant was that in the interim, the village had changed its law on gross square footage and changed it so that accessory dwelling units like this had to be added into the gross square footage of the principal structure. And if that was the case, and it was if it was so altered that it was a new structure, the house was over what was then permitted in the gross floor area. So they came back in and asked for an interpretation on 2 things. One was, is it an alteration that's acceptable, that maintains the building as what it was, or does it make it a new building that would have to comply with the new statute? So that was one of the 2 things the board considered. And the other item that the board considered was whether or not putting mahogany on the roof was a deck, because obviously it's an attractive material, it sort of invites use. And so there were 2 aspects to the interpretation. And during the hearing, the applicant repeated the representation that it would never be used as a deck, and maintained that posture because Mr. Caruso was still objecting to it. And what the board did is the board held, as one of the 2 interpretations that it made, that the placing the mahogany on the roof without a railing on it and without a doorway going into it or a way to access it was not a deck. And I think it's worth, I brought the decision with me for you, and I'll give you both the decision that was in 2011 and the subsequent decision. But I want to read the language of the subsequent decision in 2012, and that is the conclusion of the board. Without using any Latin, what the board said in plain English was, there being no door through which an access to the flat area next to the master bedroom on the south side of the second floor of the dwelling and no railing around it, the board finds that the open area is not usable as a deck, shall not be usable as a deck, and is not therefore a deck. So I suppose a lawyer can get up and tell you that when the board makes a finding based on the fact that there's no railing around it, that's somehow extraneous to the decision. But I would suggest that's not a very persuasive argument. And this language, I think this Latin that's supposed to dazzle you with the knowledge of lawyers that this is dicta, is just simply untrue. Just if you want to digress into a point that lawyers find interesting, but board members maybe less so, dicta is when a court makes a comment that's extraneous to the issue that it's considering and isn't necessary to make the decision. And the interesting reason for this distinction is that the law wants boards to focus narrowly on the issues, because that is a way that tends to support the decisions they make, because there's not a lot of extraneous stuff going on that people can point to and object to. So they ask courts and boards to narrow their focus to what the facts are. And I would suggest to you that when you read this decision, there's no question that the finding that there was no railing around this space is central to the finding of the board that it was not a deck, would never be a deck, and could not be a deck. And it's the reason I talk about the context of this application is because there's a reason that the village law requires you to have a unanimous vote to reopen and reconsider a prior decision. Again, it's a little bit like the policy behind talking about what's necessary in a decision and what's not necessary in a decision. I think the state legislature recognized that it's not good practice if decisions can change over time and when new boards come in, when the facts remain the same. And it's clear that the facts are exactly the same in this application as they were 12 years ago in 2012. And I would suggest that the reason that you had to take a unanimous vote is because the legislature wants to discourage this kind of reconsideration, because we all do better when zoning board decisions are consistent and remain consistent when the essential facts remain the same. And in fact, the case law on when you should act and when you should not act is clear, that if there's no material difference between the original application and the new application, in this case, the one that's coming in 12 years later, then there's no basis to change your earlier decision. And that's why both the vote to open and consider and the vote that you take has to be unanimous. They both have to be unanimous. The fact of the matter is that this argument that it's a new application because now we want to make it symmetrical. We want to make it look symmetrical. Frankly, is a pretext. It doesn't go to the substance of the decision that the prior board made 12 years ago. And it doesn't change the facts that the prior board 12 years ago considered, that the absence of a railing was going to discourage and eliminate the possibility that it be used as a deck. And so I would suggest that, when you look at this thing, not narrowly this is just a railing and it's just X distance from the wetland. This is a house that's got a tremendous amount of relief from the get-go. The applicants bought it with the knowledge of what was there and what was permitted. They obviously did title work on it. They had access. They're charged with knowing what the zoning on the house is. And there's no, this idea that it has to be symmetrical is not really, it's sort of a distinction without a difference. The real issue here is that the planking, the mahogany planking, invited use. The original owner knew that and made a commitment that it would never be used as a deck, and repeated that commitment in the application a year later. And the house and the buildings have already gotten very substantial relief. It's a larger house than could then have been permitted under your gross floor area limitations. So this is just one more bite of the apple 12 years later. Without the Latin, there's no material difference between the two applications. This is exactly the same scenario. They're just trying to nibble away piece by piece at the protections that a prior board, equally wise, equally concerned about the character of the village, put in to make sure there would never be a deck. And I would suggest that it not be changed. I would like time to look at this carefully, talk to my client, submit some further pictures to you. I can do that in writing. I will say that when I...
Can we get that prior to the meeting, though? I mean, keeping this meeting open longer. If you can get us...
I can
not last minute, please.
Yeah, well, I want to tell you, I'm telling you now that we started calling the village on Monday to ask for documents. We called every single day this week, and I think council knew that I was on the case, and I didn't even get a copy today. So we all, that happens.
Thank you.
But okay. I just wanted to make one other point, and that is that I am familiar with the room arrangement. There's a study at the top of the stairs, and there is a view that I don't think they're referring to that shows a more exposed portion of the Caruso backyard than what they're suggesting in their photos. So we'll show you some pictures of that. That's what I have for you. Thank you.
Thank you. Thank you.
Appreciate your time. And I apologize for the interruption. I so rarely have to.
You're not a part of the plan. Thank you. Can we move on to the new hearings for today?
I just want to make a comment for the record. I don't find the case for the railing compelling in terms of architectural symmetry with the board. I think it's the board has acted on this, and while I have no problem hearing the application, I think the neighbors' comments are relevant, and I don't think there's a compelling case architecturally or from a safety need, given that there's no access, there's no legal access to this roof in any event, and I don't see the architectural rationale.
Okay, thank you, Mr. Rose. Okay, any more comments? We'll keep it open until next October 11th. Thank you. New hearings.
Mr. McGurk.
Would you feel the need? Or Denise?
Thank you. Denise Shern again for the applicant. I just wanted to point out a few things. First, I know Mr. Bragman talked a lot about the 12 years ago and what was approved back then. I just want to make clear that that was a prior owner. This is a new owner. They've owned the property for the last 3 years. And I also want to point out that the definition that he gave for dicta is incorrect. And I know your attorney can just look that up. So I just wanted to clarify that. But what the board was saying at the time was that they were concluding that the overhang was not going to be used as a deck, but the factors that they considered were a commentary. They weren't actually necessary for the determination. The determination was based on the fact that the applicant said that they were not going to use that portion of the property as a deck, and that remains the same today. They don't need the space as a deck. It's just an overhang that provides a view to the outdoor space from the landing. And I would also just keep in the board's mind that, application before you requires you to weigh the benefit to the applicant versus the detriment to the neighbor. And here, based on the visual evidence, I would propose that there's no actual detriment to the neighbor.
Thank you.
Thank you.
Apropos of that, understand your point about the detriment to the neighbor. What is the benefit to the applicant? 'Cause
Thank
that's
you.
that I don't
Okay,
understand.
that I'll explain. So when you look out backyard from this overhang, what you don't want to see is asphalt shingles here. And that's really the only other material that we could come up with that would not be wood, but the rest of the house is covered in wood. So it would be very strange to have one roof on the whole building be asphalt, just to make sure that they don't do something they said they wouldn't do, which is use it as a deck. They really don't need to use it as a deck. It's only 93 square feet. They have a much larger deck on the other side that actually has fixtures on it, tables and chairs. That's what they use.
So understanding the aesthetics of the covering.
Yes.
What's the rationale for the railing?
Oh, safety, definite safety.
So I go back to my previous comment.
All I'm saying is that I've been on an ambulance for 25 years. I've seen people fall off of these structures. It's not a pretty situation. And I keep my windows locked in my house so my kids don't crawl out of them, but it happens. It does. It's not something to take lightly.
So not to argue, I'm just stating for the record, my observation is creating a wooden deck and then create something of an attractive nuisance. So you're having a railing to then protect against someone going out onto a deck it's not supposed to be a deck in the first place.
Right.
For which there's no access.
An attractive nuisance that was created by a former owner that we want to make sure that our kids don't bear the brunt.
Mic check. I can't hear you guys for some reason. I just lost audio. One sec. Oh, the audio's back.
Yeah, Jody, I toggled to our backup. You can go for it. We'll fix it in a bit.
Copy. You're good to go.
Again, Mark Goldfarb for the record. I just want to clarify a couple of points. First of all, as council stated, the prior owner is the one who installed the mahogany flooring. We did not. It would be, in our view, irrelevant and silly to require us to incur an expense to tear out mahogany flooring that frankly does look good from the vantage point of sitting in the study area. Nor is it visible, the flooring certainly is not visible to anybody other than us. So the idea that somehow the surface of the floor is relevant to the neighbor is frankly hard to imagine. Secondly, it's my understanding that the principal issue before the board here is the impact upon the wetlands. This is a freshwater wetlands permit, and I respectfully state that there is no effect whatsoever to the wetlands by placing a railing on a deck that already, on an exposed roof area that already exists. To the question that was raised about the benefits to the applicant, I want to be clear, and I mentioned this at the last hearing, our concern about a curious child somehow getting out of that window. I do want to make it clear, we do not intend to use this as a deck. We are not asking to change the character of this area to a deck. As council has stated, we have one. The additional reasons, in addition to safety, are number one, the aesthetics when I'm sitting at the desk looking out of the window, and number two, the aesthetics of when you're in the backyard. I think, as you can see from the pictures, the house does have an unbalanced appearance when looking at it from the backyard. There is a railing when facing the house from the back on the left side, the north side, and all we're asking for is to place a railing on the right side. It could either be a matching railing, or as we have suggested to the neighbor, we would replace the existing railing on the north side with the least intrusive railing on the market, which is a cable railing that would simply have, a couple of wood, very simple posts that match the house. And we would do that on both sides if that were more acceptable to the neighbor. And I guess the last thing I will say is it's quite clear from the history of this case, as well as what we apparently inherited, that the applicant is unhappy that this house was built in the first place, and I understand that. But counsel for the neighbor has spent an awful lot of time explaining how many variances were granted, et cetera, all of which is completely irrelevant. That decision was made 12, 11, 13 years ago, and then again 12 years ago. The house is built. The incremental decision that we are here to discuss is simply the putting of a railing around an exposed area that, to me at least, presents a safety issue. And it's simply that simple. You can't, there is no good view of that railing from the neighbor's property. I think the pictures make that clear from both sides. And I'm frankly at a loss to understand why we're even here discussing this issue, with all due respect to everyone involved. I don't know why this was even an issue in the original hearings as to what the character of this area is, but it's just unclear to me why we're having a discussion about a simple safety railing. I thank the board for its time. Thank you. Thank you.
Mr. Chairman, I just want to hand you some documents.
We already have these.
They're in the original.
Did I already get them?
Yeah.
They're in the original application, they're always submitted.
Okay, well then I have three words.
That's unlikely.
A child safety device can be put on that window very easily.
That's more than three.
4. Child safety device.
Thank you. Okay.
I rest.
We'll continue this on October 11th. Thank you. Please get all the material together with each other if there's any. Please. New hearing for the day, please.
Application of Abraham M. Dweck and Robert Levine, Suffolk County Tax Map Number 301-8-7-33.16 for area variances from Chapter 278 zoning to make alterations and construct additions to an existing residence, to construct accessory structures, and to convert an existing garage to a pool house. A 127-foot variance is requested from Section 278-3A 13A to construct additions resulting in a residence containing 3,164 square feet of gross floor area, where the maximum permitted gross floor area is 3,037 square feet. Variances of 15.4 feet, 14.5 feet, 10.3 feet, and 10 feet are required from Section 278-3A3 to construct additions and make alterations to a residence located 19.6 feet from the front yard lot line, construct covered and uncovered porches 15.5 feet and 24.7 feet from the front yard lot line, and construct a cellar egress approximately 25 feet from the front yard lot line where the required front yard setbacks are 35 feet. A 26.6-foot variance is requested from Section 278-3A5C to convert a portion of an existing garage into a pool house located 3.4 feet from a side yard lot line, where the required side yard setback for a pool house is 30 feet. The subject property is 20,378 square feet in area and is located at 19 Mill Hill Lane in Residence District R40. This project is classified as a Type 2 action in accordance with SECRA. And then I'll just state for the record who's sitting as well. So we have Mr. McGurk, Mr. McMullen, Mr. Rose, Mr. Barris, Ms. Fitzsimons, Mr. Carmelli, and Mr. Darko.
Hi, Lori Wiltshire for Land Planning Services.
Can you swear Lori in, please?
Yes.
Thank you, Lori. Thank you, Gabby.
Please raise your right hand and state your name and address for the record.
Lori Wiltshire with offices at 231 Pantico Road, East Hampton, New York.
Thank you. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thank you.
Morning.
Good morning. So the application is for variances necessary to construct additions to the existing residence, a basement egress, and to convert part of an existing garage to a pool house with plumbing. A small GFA variance of 127 square feet is requested, along with 4 front yard setback variances. All of the requested variances are due to the location of the pre-existing non-conforming residence and garage on a lot that is only 20,000 and change in an R40 zone. The house currently sits 19.6 feet from the front yard line, and the garage is situated 3.4 feet from the side property line. Granting the requested variances will not cause any change in the character of the neighborhood or produce a detriment to nearby properties. The finished house will be very much in keeping with the neighborhood, which contains some rather large houses when taking the lot areas into account. Submitted herewith are letters from owners of 15 Mill Hill, 23 Mill Hill, and 1 Meadow Way. These were all immediate neighbors, both sides and across the street. They're all in favor of the application. Unfortunately, due to the location of the residence and garage, and because the property is substandard in size, there's no other way to achieve benefits sought other than the requested variances. The proposed one-story addition is in the only location possible, and the conversion of a small portion of an existing garage makes more sense than constructing a separate structure for a pool house. While some of the requested variances may be considered substantial, this is due strictly to the location of the existing structures and should not preclude the granting of the variances. The proposed improvements are in keeping with the neighborhood and would have little or no impact on the nearby properties. There will be no adverse environmental impacts. An IAOW-TS has been approved by the Suffolk County Health Department, which is a major improvement over the existing septic system. The property is not in an environmentally sensitive area. Given the location of the existing residence, the alleged difficulty is not self-created, as there's no alternative method to obtain the benefits sought without granting some relief. Variance has been granted to 15 Mill Hill Lane for similar front and side yard setback relief, as well as for GFA. Also 43 Mill Hill for multiple lot line setbacks and GFA, for construction of a swimming pool and additions and alterations to the residence and an accessory building. And at 78 Mill Hill, they got side and rear relief to allow pool equipment in an existing garage. And I'm just going to submit copies of those determinations along with a couple of photos. Based on the foregoing, we respectfully request the board grant the relief. And I will say that when you see these photographs, that the front yard is hedged, and the side yard, where the garage is, it immediately abuts the neighbor's garage, which is also about 3 feet off the property line. So it should have no impact whatsoever on the neighbor who's already issued their approval of the application. Support. And my clients are here and would like to say a few words as well, but I will make myself available for questions.
Before this client says this, Justin, just review the math, please, in terms of the degree of additional variance at 100 and some odd feet of GFA.
127.
127
Mm-hmm.
feet. That is from that which is permitted as of right?
Correct.
That's with all
That's over what's permitted by code. 127. That's just a very small amount of GFA relief compared to other applications that we've been involved with in the village. Would you like to say?
Yeah. Thank you for your time. My name is, I'm sorry.
You're here to turn.
Yeah.
Please raise your right hand and state your name and address for the record.
Abraham Dweck, 19 Mill Hill Lane, East Hampton, New York, 11937.
Thank you. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thank you.
So my name is Abraham Dweck. That's my husband, Robert Levine. We've lived on Mill Hill Lane for the last 12 years. We moved there from Bridgehampton because we wanted, when we had our children, we have twin girls who are now 17. We wanted them to be part of this village life and something we've really enjoyed. As they've gotten older, friends, boyfriends, we need a space where we could accommodate their friend group and their significant others. At the same time, Robert and I have flexible work arrangements and would like to spend more time out here in East Hampton when our girls go off to college next year. So part of the request for the 123 square feet was to accommodate an office space that we'd like to have so we could set up our offices out there. We do intend to move out here full time when we can, and this has been a beautiful 12 years in the home, but the home needs a major renovation, and now we decided it's time to do it. So we hope you'll entertain our variance request, and we appreciate your time.
Thank you. Does anybody in the audience have any? I guess there's nobody in the audience. Board members?
I have a couple questions or comments. I know in the past we've looked at these structures on these lanes. Actually, one just recently last year, where the massing starts to become an issue. That this one here, it is a rather small house right now, and going with a 2-story front plate and building a second story over the projection of the entry, I just think that it's going to become very large looking, especially seeing that it's closer to the road than the setbacks allow.
Which structure are you talking about?
The whole house, the whole front facade of the house has now been raised to a salt box look, and you've put a second story on your front entry from the existing. I don't have anything to say about the addition that's set back further.
Right. Yes, it's he recognized that. He said the second story over the existing foyer.
Yes.
It already is.
It already has a second story. It exists now. So that structure,
your existing elevations don't show that.
the photograph.
Where are they?
You have them on the
table here.
Right there. There's the picture of the front yard, and you can see the hedge, and then right behind the hedge is the existing second story.
So this here just shows a half moon
window. Is that second story usable?
Is it usable now?
Yeah.
I'm making it a little larger. It's an office that they're trying to make a little larger.
It doesn't change.
So it's making it pitch different, Jim? Okay.
Yeah, so it shows here that it's just a gable thing, where this is just a one story plate.
On the plans, this whole thing increases in height to be.
Yeah, so this shows us a single story plate with a half one. This has a 2-story plate.
When you're saying that this right now is second story office.
Right, so this is still getting larger.
It is getting slightly larger.
The massing is getting larger. This first floor plate here, which faces the road, is now going up higher and becoming a much higher plate shown in this section.
So your concern is this?
Yes. This and this plate. So just the massing has gotten larger towards the front of the property, and seeing that it's over its permitted front yard setback.
Mm-hmm. But it is fully hedged as well.
Right.
Which will eliminate some of that massing for sure.
Yeah, and you're, well, you're.
Oh, the massing.
You won't eliminate the massing,
Yeah, massing's up top.
you're saying it'll mitigate the visual impact.
Yes. Along with the trees.
That's my only comment.
And the neighbor on Meadow is facing that.
Right. So the neighbor that wrote a letter in support is across the street.
Yeah,
Neighbor letters are great, but they have nothing to do with the process.
actually, I had a similar question related to the second story dormer area above the door. Right now, it's proposed for storage, according to the plans.
Yeah, it's true. You have the plan.
On page, drawing A7.
On A7, it does say proposed storage, yes. It does. But you intend to keep it as an office. They intend to keep it as an office.
How much is big this question? I apologize, but a whole lot of paper here. What, the degree of intrusion into the existing, the pre-existing intrusion is into this front yard is how much?
The existing is, ouch, I have that survey right here, sorry. Presently, it is 19.6.
And what is required?
In terms of relief?
What is the existing setback by code?
The existing setback is 19.6 feet.
That's existing on there, but by code, what is the front yard setback?
Oh, sorry.
25.
25?
35.
Thank you.
Yes.
I understand Jimmy's point now. In a way.
So you're concerned about the squaring off of the roof, not the little second story above the foyer.
It's more of the impact it has on the neighborhood as it is already encroaching on the front yard setbacks.
Mm-hmm.
Now you're making the massing much larger and becoming much more of an impact on the street. So if you have an existing setback of 35 square feet that you're supposed to adhere to, and you're at 19.6, you're over 10 feet closer to the road than what the code requests. And you're enlarging that massing on the second floor.
Increasing the degree of noncompliance.
Yes.
Understood. And then the porches themselves, which are not in that, so your objection is to the front of the house, the front,
Yes.
not to anything else that's proposed here.
Yes, that is my concern.
I think that's just following up, I think that's a legitimate concern and point, and the challenge in these small properties and small lots is where there's renovation being proposed and expansion, to kind of do so in a way that, to the extent that this board permits, to do so in a way that doesn't change the character of the area, the purpose for which the code is enacted.
We had a similar issue on Cheryl. Similar situation.
Yes.
Anybody have any objections to anything else on the application?
So they were just pointing out that the additional height is only 2.5 feet, and there's no pyramid relief required. They have 7-foot ceilings right now in the second story, and they're just trying to make it another 1.5 foot taller.
What would you like to do? We can leave this open.
That's what I'm asking. I think what they'd like to do is address the architecture based on your comments. So we will like to keep the hearing open.
Great.
And we will only be addressing the front facade, nothing else in our application.
Thank you. That's right. Thank you.
Thank you.
So we will keep this open to October 11th.
Okay, great. Thank you.
Thank you.
Thank you.
Okay, we have the second hearing of the day. Debbie?
Application of Maximus LLC, Suffolk County Tax Map Number 301-7-3-7 for modification of prior zoning board of appeals determination that granting variances from chapter 278 zoning and a wetlands permit in accordance with chapter 163 freshwater wetlands to raise the existing residence and construct a new single-family residence. Applicant requests to modify the determination to allow the project to be completed in 2 phases and to extend the permit for a period of 5 years. The subject property is 97,110 square feet in area and is located at 54 Georgia Close Road in Residence District R160. The property fronts on the Seabury Creek section of Georgia Pond and is located in FEMA Flood Zone AE10. This project is classified as a Type 2 action in accordance with SECRA.
Thank you. Ms. Margot, can we have Billy just talk real first, please?
Absolutely.
And give us the, you don't want to talk on, we can kind of streamline.
Do I not want to talk? I have an option?
Well,
Mr. McGurk, do you want me to just?
Yeah, say who's sitting on this, please.
So sitting on Maximus LLC, 54 Georgia Close Road, Mr. McGurk, Mr. McMullen, Mr. Rose, Mr. Barris, Ms. Fitzsimons, Mr. Carmelli, and Mr. Darko.
Good morning, Billy. Good afternoon.
Chairman, members of the board, Billy Hajak of the Village. This was an application that the board reviewed and approved, I think it was about 2 years ago. And the application was to demolish the existing house, carefully demolish it by dismantling it by hand. It was a construction protocol approved. Use the existing foundation by making it FEMA compliant, and then constructing a new house, a new modern house on the exact foundation. They were going to use it carefully with like a SIP style or modular type construction. The crane was carefully placed. It sounds as though the applicant would request more time to decide what they want to build on the foundation. So the request now is to ask for a phased application where they would dismantle the house, and the new protocol is consistent with the plan that was already approved, and then allow them 5 years or whatever time is deemed necessary to design and put a new house on top of the existing foundation. I suppose at the end of 5 years, they would have to come back and ask for either an extension or deal with the foundation that's still in the ground. So they have the only change is it looks like the driveway is slightly redesigned and the curb cut is being relocated, but the driveway is outside of the required wetland setback. So,
you don't see this?
No, it's consistent with the DEC permit that was issued.
When you say outside of the...
Beyond, beyond the setback.
Okay. Anybody have any questions for Billy?
No, sorry.
Go ahead.
So it just is when we originally heard this, it was anticipated this would all be done as one piece. There would be, and did we see the design for the house that was?
Yeah, you approved. Yes, the board approved the set of.
So now this is my concern. It's a question. Sorry. I don't want to see if we're doing this. We approved something for design to go on a foundation for an existing and a sensitive area. 5 years to see with a dismantling of the house on a foundation with a hypothetical design to be proposed down the road.
I would like the applicant.
I just want to make sure I understand.
I could be misunderstanding, but maybe the applicant can.
Just want to understand exactly what's being proposed.
And I think we wanted to make it consistent with the DEC 5-year permitting process. That's kind of really the gist of this, I think.
I would maybe the applicant can clarify.
Sure. Good morning.
Good morning.
Mr. McGurk, members of the board, Linda Morgan, from the Akron Cochran Brown.
Goldstein and Margolin. The intention here was to give the applicants more time to go ahead and build. The current building is deteriorating. They want to take it down, and because they want to phase it, they will backfill the foundation appropriately and landscape around it. And in order to get the one thing that they do need right now, which is some additional parking area, because they own the lot next door, which already has a house on it. They're going to put a driveway and small parking area in an area that is outside of the wetland setback. So we're not asking for any additional relief beyond what was granted by this board in 2022. And if the applicants ultimately decide that they want to do a different design for the house, they will have to come back to this board. We're not asking you to approve God knows what going on the same foundation. So that's the scope of our application, and we're asking to have it phased so that if something happens, the beneficial owners here are in their 80s. If something happens and in fact the property passes out of their ownership to someone else, the property won't be in limbo with half the work completed and unable to obtain a certificate of zoning compliance or a CO.
Thanks. I have one question. So we did this 2 years ago, correct?
Yes.
Are you looking to extend it?
I can tell you exactly what we're looking for. Because
3 more years?
I can tell you exactly what we're looking for because since we made the application here, we got the DEC permit. And the DEC permit, which we submitted to this board, runs through August of 2028. So we would like the same termination date.
So my question goes, and I'm not sure if this is to the applicant and to Billy, in terms of the constraint of the operating with the existing foundation, which is material, as I understand it from reading it, it's material to the DEC permit, and it was material to the approval of this board in terms of the original application. That's correct? So I just want to be very clear in this action. So obviously someone has the right to apply potentially that the constraint of operating with the existing foundation and the preservation of the existing foundation over the course of the 5 years that this is being granted for is something that is not a game. This is not a come back and do a bait and switch. This is the constraint that is being that this board has acted on and will be expected to be pursuant to it.
Yeah. Tim, I have a question for you. With an application like this, we have an approval that has a deadline. Are we opening ourselves up to something where we give a 5-year extension to this? Are we opening up the board to more applications like this that could render us, I don't know, but also, is it something that we do on a yearly term and have them come back each year?
The ability to grant the extension is in the board's power and discretion. I don't think it exposes you any more than consideration of anything else.
Thank you.
Yeah. Joe, if I may, this request was prompted by the fact that it took over 2 years to get the DEC to approve this sensitive application. Over the course of that period, Millie and Arnie Glimsher, who are my contemporaries, they weren't sure how far they were willing to go with this project. They were very enthusiastic, but over time, they became very unhappy and uncomfortable with the fact that the DEC was taking so long. As you all know, as we get older, we're not so sure of our future. They just would like to be in a position to enjoy this lovely property, which is adjacent to their home. And at some point in time, over the next period of time, in less than 5 years, they'll decide what they're going to do with the property. Meanwhile, they're going to enhance it aesthetically. They're going to make themselves comfortable with it, and then we'll proceed. There's no game playing here at all.
Thank you, Mr. Ackman. Anybody have any questions? That's fine. Billy, you're
Okay. All right, thank you very much. A motion to close the hearing? So moved. Second? Second. All in favor? Aye. Aye. So Mr. McMullen and I are recusing ourselves on the last application of the day. And we're gonna, and the chairman, Mr. Rose, if you can close the meeting. Appreciate that too.
Application of Richard A. Shilowich Living Trust, Suffolk County Tax Map Number 301-1-1-28 for area variances from Chapter 278 zoning to construct additions to an existing residence that exceeds allowable gross floor area. A 754 square foot variance is requested from Section 278 3A 13A to construct a 105 square foot addition resulting in a residence containing 2,608 square feet of gross floor area where the maximum permitted gross floor area is 1,854 square feet and the legally pre-existing gross floor area is 2,503 square feet. A 303 square foot variance is requested from Section 278 3A 9A to permit 2,511 square feet of coverage where the maximum permitted coverage is 2,208 square feet and the legally pre-existing coverage is 2,601 square feet. The subject property is 8,540 square feet in area and is located at 31 McGurk Street in Residence District R40. This project is classified as a Type 2 action in accordance with SECRA.
Good morning, board.
I'm just going to swear you in.
Yeah.
Please raise your right hand and state your name and address for the record.
Richard A. Shilowich, 31 McGurk Street, East Hampton.
Thank you. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. And then I'm just going to state who's sitting on the record. So we have Mr. Rose, Mr. Barris, Ms. Fitzsimons, Mr. Carmelli, and Mr. Darko.
Okay, good morning, board. Thank you for your time. The application, I assume you've all seen the plans and read the memorandum of what the process was for us. This house, as it exists now, is pre-existing non-conforming that we know. And for the record, this particular house, the way it sits with a C of O for everything I own, has never had a variance. So everything we have done in the size and whatever's there was done by the old zoning. So we had certain needs on the inside for our own personal reasons why we needed to move things around for our, the basement stairs and going up and down to the basement a million times a day because everything is in the basement because we don't have enough room in the house. So we're taking away a room that exists in the house to create a bigger kitchen, to create a better mudroom space, to have more things be on the first floor. And by doing so, we've lost sort of the den in the house. So there is an existing, as you see from the plans on the south side of the house, there is an existing mudroom that sticks out 12 feet. And so the only way to really acquire a proper sized den was to extend that room by, I think we extended 6 more feet. It's 105 square feet is what we're gonna remove that existing structure. It isn't gonna come any closer to the property line, and it's going to become 105 square feet wider to now accommodate a new den. We were very careful to keep it as a 1-story addition. So when you look at the 2 proposed front elevations, other than it gets 2 feet taller, I think it's 2 or 3 feet, maybe it's 3. You really don't see any difference from the front elevation. The only property that sees a difference in the width is 29 to the south, which my wife owns that property. We own that property, so we're the only one that really notices the size width change. And then just adding that little covered porch. Other than that, the front of the house, the height of the house, everything else remains untouched. We have over coverage by current zoning on the area coverage. By doing all this and removing parts of patios and other pavers and whatever, we will be reducing the coverage, even with adding all this, by 100 square feet, I believe it is, or something like that. 100 square feet, give or take 110 square feet, we'll be reducing the coverage once this is all done. I don't know what else I can say. Does anybody have any questions?
Can you speak to just the GFA calculations as well?
Yeah, they're on this one plan. Everything, the GFA and the proposed and the coverage plans are both on that. So it's going from 2503 to 2608. Oh yeah, so we have 12 letters in the file for people that they are fine with it, and we have no opposing neighbors.
Any questions?
I have no problem with this.
Questions, comments? Any other speakers on this matter? Okay. Motion to close the hearing on this?
Second.
Okay. Approved, thank you.
Great, thank you very much.
Any other further?
Thank you for your time.
Any other further business? There being none, any motion to close the hearing?
Motion to close the hearing.
All in favor?
Aye.
Hearing is closed.